Lawyers for Donald Trump asked an appeals court to toss out the criminal federal election subversion case against him. It's yet another attempt by the former president to assert he's protected from criminal prosecution by presidential immunity. The filing came one day after the Supreme Court rejected special counsel Jack Smith's request to fast-track the case and bring the immunity question directly to the highest court. CBS News legal contributor Jessica Levinson joins us now with the latest on this. Jessica, good to see you. One of Trump's arguments is that he can't be prosecuted because of double jeopardy. Remember, the Senate acquitted him of similar accusations in his second impeachment trial. So help us understand that argument and if it has any merit.
I don't think it has any merit. Double jeopardy, exactly as it sounds, is intended to prevent people from being charged with the same crime twice. The idea is if I'm charged with burglary, for instance, and I'm acquitted, then I can't later be charged for the same crime based on the same facts. I have to have some finality when it comes to that acquittal. But that's with respect to two legal criminal charges here. What we're talking about for impeachment and the Senate's acquittal is that occurred in a political form. And I really do not think that the same arguments hold true for wanting to prevent somebody from facing the same charges twice. When it comes to impeachment, again, that's not a court of law. We saw that many times throughout the impeachment. That really is a political decision that the House of Representatives and the Senate makes. And so I don't think that particular argument is going anywhere for the former president.
Okay, so let's now move on to why reject Jack Smith's desire to fast track the case to the Supreme Court if it will likely end up in their docket anyway.
So the Supreme Court refused to step in, I think, potentially for a couple of reasons. One, we can say that they weren't willing to assist Jack Smith. They weren't willing to respond to his request and say, yes, we will give you an answer right away because we want to keep that March trial date. Another way to read that is that they want to go through the normal course of the D.C. Circuit answering that question, and then they may not take the case at all. This question of presidential immunity, well, the Supreme Court has never given us an answer. It's really not a tough legal question. All the precedent points in favor of saying that Trump does not enjoy any immunity, that he can be prosecuted. And so we could view it either as a loss for Trump because maybe they don't really think there's a there. They want the D.C. Circuit to sort this out. Or we could view it as a win for Trump because it means the Supreme Court isn't going to fast track this.
Okay, you got to be a lawyer to keep up with all these Donald Trump-related cases. But there's currently a stay on the Colorado Supreme Court's ruling to ban former President Trump from the ballot. But that expires on January the 4th. So what does that mean, and what should we expect to happen in the 9 days until then?
I think we're going to expect that he will appeal. I truly can't imagine that Trump and his legal team will let this Colorado Supreme Court decision stand. If it does, then it stands as precedent that he's not eligible for the ballot because he violated Section 3 of the 14th Amendment. Once he appeals, then that decision is stayed potentially indefinitely. And this is a place where, unlike the question of presidential immunity, I think the Supreme Court has to weigh in. They cannot allow state by state to be a patchwork of decisions as to whether or not the former president is eligible for the ballot and what the 14th Amendment means. I think we're going to see the Supreme Court jump in, and I think we're going to see them say that, in fact, he is eligible for the ballot.
Okay, that's very interesting. So 9 key days there. Jessica Levinson, thanks for keeping track of all that.
Thank you.